3 years ago, President Obama's signature achievement was on the line. The Supreme Court was deciding the constitutionality of the Affordable Care Act. Chief Justice John Roberts joined with his four more liberal colleagues to uphold most provisions of the law. The healthcare law is on the line again. This time, Mr. Obama's Solicitor General is defending the federal tax credits for people who might not otherwise be able to afford insurance. The case is called King v. Burwell. Do we know how the justices are likely to decide this time? Experts expect it to be close once again. They're analyzing the justices' comments from the bench during oral arguments Wednesday for clues. Supporters of the healthcare law are finding hope in questions asked by Justice Anthony Kennedy. He voted against it last time. More on that in a moment, but first, what's King v. Burwell about? The 2010 healthcare law requires all Americans to have medical insurance. To help the uninsured find coverage, states can do one of two things. They can create their own healthcare exchanges, the marketplaces where the uninsured can shop for a policy. Only 13 states in the District of Columbia have taken this route. Or states can decline to do this and rely by default on the federal government's healthcare.gov system to provide people with policies. 37 states now do. The law states that individuals who purchase coverage through an exchange established by the state can, if their income is below a certain level, receive taxpayer-funded credits to help pay the cost of purchasing their health insurance. Challengers say that phrase denies subsidies to residents of states served by a federal exchange. But the Obama administration says other provisions indicate that federal exchanges are legally identical to state ones and presume the tax credits are available nationwide. The Supreme Court is being asked to decide whether the federal government is correctly interpreting the law when it offers subsidies to users of a healthcare.gov exchange. How did the arguments play out? The more liberal justices grilled the attorney challenging the law with this scenario. If states that didn't create their own exchanges could not receive insurance subsidies for their citizens, would that not be coercive in an unconstitutional way? The challenging attorney disagreed, saying that's hardly invading state sovereignty. In fact, he argued Congress intended for all 50 states to set up their own exchanges. Justice Kennedy says to the challenging attorney, if your argument's accepted, the states are being told either create your own exchange or we'll send your insurance market into a death spiral, presenting a serious constitutional problem if we adopt your argument. The challenging attorney says Congress, in the strongest possible terms, made it clear it wanted the states to run their own exchanges and limited the availability of the subsidies to states that do so. Justice Scalia, building on that argument, asked the Solicitor General, even if an interpretation of a particular provision produces disastrous consequences in the rest of the statute, it nonetheless means what it says. Is that true or not? The Solicitor General responds, I think there are a couple limitations on that principle. He tells the court that Congress meant something more inclusive when it wrote the provision that exchanges established by the state could get subsidies. He said, you have ambiguity there precisely because you have to. He says the Obama administration's reading of the law was the only one that made sense. The other side's interpretation revokes the promise of affordable care for millions of Americans. That cannot be the statute that Congress intended. Justice Kagan, supporting this view, says that the court, in interpreting statutes, looks at the whole text. We don't look at 4 words. On that point, Justice Kennedy says if the language is ambiguous, we think about Chevron. Chevron's a reference to a case in which the court held that when a statute is open to varied readings, judges should leave interpretation to the federal agency. Justice Roberts asks if a Chevron defense would indicate that the subsequent administration could change that interpretation. The Solicitor General responds, a subsequent administration would need a very strong case to do so in light of the disruptive consequences of taking away insurance subsidies. The Supreme Court could rule that the federal government must stop offering subsidies to users of the healthcare.gov system, in which case, according to one projection, in the 37 states where the subsidies disappeared, individual insurance premiums would go up 35% next year. Effectively, say many analysts, throwing the health law into a death spiral. That's the short answer.